Today, the Speaker of National Assembly, Moses Wetangula, upheld a decision that he made in the year 2022 on October 6th, a decision that was quashed and dismissed by the High Court of Kenya last week on Friday. When the High Court made a ruling, it ruled that Azimio la Umoja team were the majority at the majority of the numbers in the National Assembly. But it seems that things are turning out to be different after the ruling that was of today made by one Speaker, Moses Wetangula. But the petitioners and the advocates that had stood to defend this ruling of the court have taken this a step further. One of the lawyers that stood and fought for this case since the year 2022 until date is none other than lawyer Kibe Mungai. Kibe Mungai, as of today evening, made a certain statement in regards to the ruling that has been made by one Speaker Moses Wetangula. Lawyer Kibe Mungai has waded into the recent High Court ruling on the majority party in the National Assembly. Addressing Speaker Moses Wetangula's response to the judgment, in his letter, Mungai highlights that the court had already determined that the question of the majority party was settled by Kenyan voters in the August 9th, 2024. In the August 9th, 2024 August 9th, 2022 general elections. The ruling declared that Wetangula's October 6, 2022 decision, which named Kenya Kwanza as the majority party and Kimani Ichung'wah as the majority leader, was unconstitutional and invalid. Despite these, Wetangula allegedly reaffirmed his position on Kenya Kwanza's majority status during a parliamentary session on February 11, 2025, which is today. Now, Mungai argues that Wetangula continued a session go against the court's decision and raised concerns about constitutional compliance. He points out that as a litigant in the case, Wetangula has no legal authority to determine or enforce the ruling in favor of his political coalition. Furthermore, he notes that the court ruled the Speaker cannot hold both his parliamentary role and the leadership position in Ford Kenya and Kenya Kwanza, adding to the legal questions surrounding his position. In his letter, Kibe Mungai calls for Wetangula to resign from his leadership role in Ford Kenya and Kenya Kwanza by February 14, 2025, and to ensure the immediate implementation of the court ruling, which recognizes Azimio la Umoja as the majority party. He states that failure to comply could lead to legal action, including possible contempt of court proceedings. His intervention hands to the ongoing debate about the implication of the ruling and the political legal consequences that may follow. A letter to the Honorable Moses Wetangula, the Speaker, Kenya National Assembly Parliament Building, Parliament Road, Nairobi, Dear Sir. Reference: purported ruling on majority party in the National Assembly in the wake of the judgment in Constitution Petition number E202 of 2023, Kenneth Jagenjiru and others versus Kenya Kwanza Coalition and others. Refer to the judgment of a three-judge bench of the High Court, namely the Honorable Mr. Justice Nga J. Chigiti J. and Justice Chigiti and Justice Mugambi, which was delivered on Friday, 7th February. The learned judges issued the following orders. Number 1, it is hereby declared that the question as to which party or coalition of parties is the majority in the National Assembly as on in the 13th Parliament was determined by the sovereign will of the Kenyan voters during the 9th August 2022 general election. Second, it is hereby declared that Honorable Moses Honorable Speaker's ruling or determination contained in his communication from the chair made on 6th October 2022 on the majority and minority in the National Assembly violated Article 108 of the Constitution, and therefore it is null and void. Number 3, it is hereby declared that the Honorable Speaker ruling or determination from the chair on 6th October 2022 with respect to leadership of the National Assembly on account of his determination of the majority party and minority party in the National Assembly is contrary to and violated Article 108 of the Constitution, and to the extent it's null and void. Number 4, an order of certiorari is hereby issued quashing the Honorable Speaker's ruling or determination contained in his communication from the chair made on 6th October 2022 on the majority and minority in the National Assembly. Now that was the ruling that was made. On number 5, the subject to the foregoing orders, the rest of the prayers in the petition are declined. Number 6, parties will bear the respective cost. In summary, the judgment of the High Court determined inter alia 3 things. The court declared that the question as to which party or coalition of parties is the majority in the National Assembly was determined by the sovereign will of the Kenyan voters during the 9th August 2024 general election. Number 2, your decision issued on 6th October 2022 to the effect that Kenya Kwanza coalition is the majority party and that Honorable Kimani Ichung'wah is the majority leader was declared unconstitutional and quashed. Number 3, it quashed your decision in the same ruling that Azimio la Umoja was the minority. Now this is the letter written by yours faithful Kinoti and Kibe co-advocates. Kibe Mungai, CC, the Deputy Registrar, Constitution and Human Rights Division, High Court, Nairobi. Now, this is a letter written by Kibe Mungai in regards to today's ruling. Now, Wetangula made a ruling out of the said, how should I put it? Out of the said ruling. Now, Nairobi Senator Edwin Sifuna has insisted that the Speaker is wrong in upholding Kenya Kwanza's claim as the majority party. He cites the court ruling on 9th of August, which one of these esteemed lawyers is right. Now, on Article 108, there shall be a leader of the majority and a leader of the minority party. Number 2, the leader of majority party shall be the person who is the leader in the National Assembly of the largest party or coalition of parties. Number 3, the leader of the minority party shall be the person who, we all know these shenanigans and all that. Now, I want to read what Edwin Sifuna says. Edwin Sifuna tells us, the court was clear that the minority was determined by the voter on 9th of August 2022. What happened and what is happening now is nothing short of stealing the will of the people, which means he declares that Speaker Moses Wetangula is in violation of the Constitution of the Republic of Kenya, and as Kibe Mungai has stated, by 14th, which is 2 days from now, Speaker Moses Wetangula should have changed his decision or face charges of contempt of court. What is your take in regards to this? Leave your comment in the comment section. See you in our next video. This is the Kenyan Daily Report.